Senator Brown.
Thank you, Mr Acting Deputy President. Today, the Parliament is again considering the Morrison Liberal government's attempt to dissolve the Specialist Family Court of Australia as a standalone superior court. Should the Parliament accept this legislation, it will be a sad end indeed to a decades-old institution which has served Australia well. The Family Court of Australia, of course, is an institutional legacy of the Whitlam Labor government. It is a proud legacy and has served our nation well. The enactment of the Family Law Act 1975 saw two significant social reforms for the nation. It brought around the key milestone for Australian women of no-fault divorce, and it established, finally, and with much need, a standalone multidisciplinary court designed specifically to consider the disputes arising within the family. This bill represents the most significant change to the structure of family law in this nation since that time, 46 years on. So it is more than appropriate that this matter is given the sort of consideration and debate worthy of the institution and the critical matters it deals with. Let us briefly consider some of the history of the family law and the court in Australia. Shortly after the passage of the Family Law Act in 1975, the then Labor Attorney General, Kep Enderby, wrote that, and I quote, and I know other senators have spoken about the work of the then Labor Attorney General, but it is important that, that the Senate hear these words again, because this is a critical piece of legislation. Critical piece of legislation that needs to be defeated. Mr Enderby said, and I quote, "In public discussion of the Family Law Act, most of the attention has understandably and quite properly focused on the ground of divorce and, to a lesser extent, the maintenance provisions. While not underrating the magnitude of the reforms to the divorce and maintenance laws, I feel sure that, in time, the provision for the establishment of family courts will come to be seen as a reform of equal importance." End quote. Mr Enderby later said that the essential distinguishing features of the family court is that it would be dealing only with family law matters. This has been critical. And yet, the proposition before us today would abolish this essential distinguishing feature. It would roll the family court into one of Australia's busiest and most poorly resourced and overburdened courts, the Federal Circuit Court. And what of the modern-day role of the family court in Australia? Much has been said about its pivotal role and the vital need as an important institution. In 2019, the Australian Law Reform Commission delivered a landmark report on the family law system. A report, it should be noted in this place, that whilst the government commissioned it, has completely ignored it. In the report, the Commission noted that at the time of passage of the Family Law Act, the Whitlam government did not, quite reasonably, foresee the growth in the incidence and awareness of family violence that would come. Thus, the need for a specialist court to deal with these sensitive matters has only grown. And we must consider what specialisation actually means. At the time of its establishment, the specialised court envisaged was one in which the environment would have regard to the human problems, as Whitlam described it, of couples and families. Not simply a clinical and sanitised institution that solely considered legalistic matters and requirements. It was to be a court with interrelated and co-located services and resources for families. This is a critically important distinction, especially for vulnerable children and families in need of a safe and sensitive environment. It is universally understood and accepted that the family court system at present suffers from serious deficiencies. We need only look at the findings from the Australian Law Reform Commission, which determined that the family law system has, and I quote, been deprived of resources to such an extent that it cannot deliver the quality of justice expected of a country like Australia, and to whose family law system and other countries once looked and tried to emulate." End quote. A sad indictment indeed on the current state of affairs for families in need of a swift and quality judicial experience. The last 7 years in particular has brought about much about such neglect, and it would be hard to consider it to be anything other than deliberate. A deliberate trashing of Australia's system of family law from successive Conservative governments. It started with deliberate cuts and neglected by the government, and the neglect by the government led by Mr Tony Abbott, and continued with further cuts and neglects by the governments led by Mr Turnbull and now Mr Scott Morrison. And how has that neglect manifested itself? It starts with the failure to replace judges of the Family Court and the Federal Circuit Court in a timely manner. Despite increased demands for services, funding has not been delivered to meet that demand, and the recommendation of repeated reviews has been continuously ignored, parked on the bench to gather dust. And so, after all of that, the government solution, this bill before us. Instead of working to fix the family law system, this bill will only make this situation much worse. And that is bad news for Australian families and vulnerable people, including vulnerable children. The government's bill seeks to combine two distinct courts into one. It trashes the concept set forth by the Whitlam government of a single, standalone and specialised family court designed to deal with the sensitive human problems of family law. In combining the Federal Circuit Court and the Family Court, both these divisions would share the same single Chief Justice and Deputy Chief Justice. They would share a single set of rules and a single point of entry. Worryingly, the Appeals Division of the Family Court would not be replaced with anything. The same bench of judges will hear matters both in original jurisdiction and on appeal. When this merger was originally proposed by the government, the Attorney-General said that he would stop appointing new judges to Division 1 as they retire. That would obviously amount to a gradual abolition of Division 1, that is, the Family Court of Australia, over time. Whilst he backed away from this proposition after sustained public criticism, there is nothing in this bill that would prevent him from reverting back to his original position. He can, once again, have a change of mind and simply stop appointing judges. We are supposed to simply take him at his word. Unsurprisingly, there are few who do when it comes to this Attorney-General. Even if changes were made to this bill to guarantee the continuation of the proposed Division 1, the Family Court, it would not address the fundamental problem at the heart of this bill, and that is the abolition of specialisation within our Australian system of family law. So why such a radical departure? Perhaps the government is relying on a quantum of supporting evidence. Perhaps they've consulted widely to reach and form this view. Nope and nope. No such evidence, no such consultation. The Morrison government claims that the proposed merger has been informed by independent reviews and inquiries over a decade. On his department website, the Minister, the Attorney-General, has named 5 reports under a heading that reads, "The evidence base for the reforms." However, unfortunately, like most of the work produced by this Attorney-General, it doesn't even make sense, because not one of the reports he lists has recommended these radical reforms. In fact, none of these reports have been considered, have even considered these reforms. Just one of the reports recommended restructuring the Family Court. However, the model recommended would have maintained a standalone specialised court. Not once in almost 70 reviews of the family law system undertaken since 1974 has it ever been recommended the Family Court system of Australia should be restructured in the way proposed by this government. These reviews and reports are all listed in Appendix 3 to the interim report of the Joint Select Committee into Family Law. But the Attorney-General continues to ignore all this, continues to ignore the evidence cited by his own department and this parliament. But senators in this place should not ignore the evidence. So what does the government rely on? What evidence do they rely on? Amazingly, the most radical change to the structure of family law in Australia has been done off the back of a 6-week desktop review of data by 2 accountants. That's it. A review, it should be noted, that has been widely panned and thoroughly discredited. And what about consultations on this bill? There has not been any meaningful consultation with the legal profession or with any other family specialists like counsellors or child psychologists. There was no consultation with users of the family law system, Australian families, other than with the Chief Justice. The government did not even consult with the judges of the family court. Such a radical reform should not be undertaken with such scant regard for consultation. Yet it is no wonder the government did not wish to consult, because they would have come across naught but an avalanche of opposition. Let's look at some of the commentary, opinion and analysis on this bill. No fewer than 110 stakeholders. In fact, the letter that was sent to all members of Parliament indicates it's opposed by over 155 stakeholders, including 13 retired judges. And it also includes community legal centres, the Law Council of Australia, Aboriginal Torres Strait Island Legal Services, Child Protection Advocates, Women Legal Service, Disability Services and many more have written to the Attorney-General asking him to abandon this proposal. They have been silenced. Their views have been ignored. To the last, these opponents have made it clear that it is their combined view that this proposal will increase rather than decrease cost, time and stress for families and children in the family law system, harm vulnerable children and families in the need of specialist family law assistance, place further stresses on the Federal Circuit Court judges who are struggling under unsafe, unsustainable and unconscionable workloads, and fail to address any of the fundamental problems plaguing the family law system, including the risk of family violence survivors falling through the cracks. The very first Chief Justice of the Family Court of Australia, Elizabeth Evatt, AC, has said, and I quote, "The proposed merger of the Family Court and the Federal Circuit Court will lead to undesirable outcomes for children and families," end quote. The Honourable Alistair Nicholson, the second Chief Judge of the Family Court, who served in that position between 1988 and 2004, has fully supported Ms Evans' remarks. Mr Nicholson has also said, in biting criticism, and I quote, "It is unbelievable that government would propose the dissolution of a federal superior court in this fashion, without the most careful and searching public inquiry and without carrying out significant research and without consulting the many experts in this field," end quote. He went on to say, in pointed remarks, "The family court is a court that has been envied throughout the common law world, and its judgments have been often cited with approval by the courts of many countries, including New Zealand, UK, Canada and the US and others. Its significance as the only specialist family court set up as a superior court of record, and particularly that of its appeal division, cannot be overemphasised," end quote. There are so many groups and organisations and experts in this field that have asked the government to stop with this reform, to stop with this legislation, but they've been unprepared to listen, unprepared to back down, and it's not good enough. We know that this legislation, if enacted, will lead to worse outcomes for very vulnerable families. Amongst the people that have written to all the senators and members here, I believe, there are a number of highly specialised expert organisations in South Australia. We've got the Women's Domestic Violence Service of South Australia. We've got the Family Violence Legal Service Aboriginal Corporation SA, JusticeNet South Australia, the South Australian Community Legal Centre,
And it goes on. So I ask those senators to look to their own, look to their state experts as to what they are saying.